Ms. Malliotakis.
Thank you, Mr. Speaker. Will the sponsor please yield?
Yes, Mr. Speaker.
Will you yield, Mr. Moya?
Yes, Mr. Speaker.
Mr. Moya yields.
Thank you, Mr. Moya. I think I'm going to bring up, well, first let's start with some of the concerns that I brought up with the mayor the other day when we were talking about the sanctuary city policy of the city of New York. First and foremost, I think there's a concern by many that policies like this are going to risk federal funding and perhaps losing federal funding because these laws do not comply with federal law. Have you any concern about that, about perhaps the amount of money? And do you know, are you aware of what the amount would be that the state of New York can lose in federal funding if this were to be enacted?
Look, right now the federal government is doing a study on what that would be. But again, it would have to be something that is tied specifically to something related to this issue of immigration where we would lose federal funding.
Okay. In the memo, in the sponsor's memo, the last line I found interesting because it says that the bill complies with federal law. How does this bill comply with federal law? Number one, if it's tying the hands of law enforcement, prohibiting them from entering state premises, prohibiting law enforcement from being able to do their job, how does this comply with federal law?
So look, we are. This is in compliance with the executive order that's been given. The fact is, the statute. I don't know where you're saying that if you can point somewhere where we're not in compliance, then maybe I could answer the question.
So on Title 8 of the U.S. Code 1324, there's a subsection that deals with harboring. So if it makes an offense for any person who, knowing or in reckless disregard of the fact that an alien has come to, entered, or remains in the United States in violation of law, conceals, harbors, or shields from detection, or attempts to conceal, harbor, or shield from detection such alien in any place, including any building or any means of transportation. So my understanding of this, and I think that the law speaks for itself, is that we tie the hands of the law enforcement. Those officers are subjected to violating this statute, which comes with a penalty of 5 years in prison.
We're not harboring anyone.
Well, if we're not complying with federal immigration detainer requests.
If there's a judicial warrant, we're in compliance.
Okay. I think there's a disagreement on that when we are in compliance or not, because right now federal law, which does trump, no pun intended, does trump state law, does not require a judicial warrant. So
But the Fourth Amendment of the Constitution does. And that's why we're saying...
The Constitution for citizens, or...
It's for all persons.
Constitution. So
It says for all persons.
Oh, okay. That is not true, but okay. There is another law, also in Title 8, Section 1373, which is another example of how I believe this law that you're putting forth would violate federal law. It says, no person or agency may prohibit or in any way restrict a federal, state, or local government entity from doing any of the following with respect to information regarding the immigration status, lawful or unlawfulness of an individual. The government entity or official may not prohibit or in any way restrict any government entity or official from sending to or receiving from the Immigration and Naturalization Service information regarding the citizenship or immigration status, lawful or unlawful, of any individual. So again, under federal law, that's what the federal law says. It seems to me that this bill that you've put forth does not comply with that.
It does. This bill, for example, complies with the information sharing requirements of 8 U.S.C. 1373. But federal law does not require that all personal information about an individual be collected. And the federal law does not require that every bit of information collected about an individual be shared. 1373 only requires that the state and local government entities and officials do not prohibit or restrict the sending of information or receiving of data regarding citizenship or immigration status. So if a federal immigration authority asks a state or local agency, they must share that information.
Yeah, but I think so. Those two sections of the federal law that I mentioned, I think it's a really slippery slope here, especially without law enforcement, because we're really asking them to violate the federal law. And it's fine. I mean, you could pass a bill that's a state law, but nonetheless, the federal law is going to trump the state law, and the federal law does not require that a judicial warrant. And so we are violating that any way you look at it. But also, you mentioned that we comply with Trump's executive order with this bill. So under this bill, if an individual is convicted of any criminal offense, would we comply with a detainer request?
If there's a judicial warrant, yes.
Only if there's a judicial warrant,
Yes.
which federal law does
If
not
they're
require.
on a terror watch list, if they have re-entered the country after being deported and are a violent felon, yes.
Okay, well, the executive order says if an individual has been convicted of any criminal offense, and there's a few other things here, engaged in fraud or willful misrepresentation in connection with any official matter before an agency, have abused any program related to receipt of public benefits, there's a few other points here, but again, they don't require a judicial warrant on the federal level, so we would be not complying with federal law. In the language of the bill, and we had a conversation about this earlier, so I don't know that your intent is really what it says here in the bill, so I just wanted to get clarification. It says here on page 5, B, section B, line 2. It says that the person had to have illegally re-entered the United States after a previous removal and, which is the important word here, and the person stands convicted of a violent felony offense or a Class A felony offense, either one of those offenses, right? So you're saying that an individual has had to previously be deported, return here, and commit a felony offense either in the first degree or a violent felony.
Yeah, but again, a judicial warrant would...
Okay. So basically, if an individual is here illegally, was never deported previously, and they commit a felony, under this really doesn't require that you comply with a detainer request.
Yes, with a judicial warrant.
With a judicial warrant, but not without one, which is what the federal law currently says. Okay.
No, it does not
so
say that, by the way.
a slew of other crimes I've mentioned with the mayor that the city policy doesn't include crimes like grand larceny, sex abuse, forcible touching, patronizing a prostitute who is a minor, welfare fraud, identity theft. There are drunk driving. There are countless crimes that the city sanctuary policy turns a blind eye to and ignores and refuses to allow law enforcement to comply with judicial requests. Is that the same case here with the state policy that you're putting forward?
No, so look, detainers aren't always accurately issued. So let me give you an example. Between 2008 and 2012, ICE logged in 834 detainers against U.S. citizens, 87% of whom had no criminal convictions. Between 2008 and 2012, 28,489 detainers.
I'm sorry, with all due respect, that's not my question. My question is, in those cases, those crimes that I mentioned, grand larceny, sex abuse, forcible touching, patronizing a prostitute who is a minor, drunk driving,
But if they're,
welfare fraud, identity
if
theft,
they're in criminal
those
court,
cases,
if
if
they're
they're
in criminal
convicted, do
court,
you comply with a federal detainer request? In
so
those cases?
you would need a judicial warrant. If they are convicted of a crime, if the judge sets bail, if they make bail, there would be a judicial warrant that would have to go after them for their deportation process.
And in all these cases, if these individuals commit all these crimes, now the taxpayer has to foot the bill to defend this person who's a criminal, right? They committed these crimes. The taxpayer has to foot the bill to defend them, correct?
Yes, we
Okay.
do that now. We have social service programs. We provide legal services in many, many other cases in our judicial system. This would add to making sure that if there is a process in which an individual is in immigration court in the process of being deported, they will have access to an attorney that deals with immigration law.
Okay, thank you, Mr. Moya.
Thank you.
On the bill,
On the bill, Ms. Malliotakis.
just to wrap it up, I really believe this is a bad policy for a number of reasons that I expressed during the debate. Number one, it doesn't comply with federal law. We are in jeopardy of losing potentially billions of dollars if we do not comply with federal law. And I don't know why anyone in this room would want to risk funding to protect their constituents, the citizens that actually elected them to represent them here, to harbor individuals who are in this country illegally and committing crimes, including felonies, violent felonies. So I think we really need to take a step back here, away from the politics, look at the policy, and see that what we're doing here is not only potentially dangerous in terms of losing federal funding, but it is also a concern in protecting the safety of our citizens. Again, we are here to protect the citizens of the state of New York. That should be our priority. That should be government's priority. To sit here and debate for hours legislation that would protect individuals who are here illegally and committing crimes is really, frankly, I don't believe what our constituents are sending us here to do. So I will be voting against this bill. I urge my colleagues to do the same, and hopefully it won't come up again next year.